Recent guidance from the nation's top workplace safety regulator making some employers think twice about mandating vaccinations. The latest guidance from the Occupational Safety and Health Administration, or OSHA, says if you require your employees to be vaccinated as a condition of employment, i.e. for work-related reasons, then any adverse reaction to the COVID-19 vaccine is work-related. But is it legal to put that kind of liability on employers? Let's discuss that question with former U.S. Attorney Harry Litman and criminal defense attorney David Bruno. Welcome back to the show, gentlemen. Good to see you.
Thanks.
Hello, Shannon.
Okay, so a little bit more from OSHA, because there's a Q&A section here, and they're talking about whether we recommend people get this before they come back or we require our employees. It says an employee who chooses not to receive the vaccine cannot suffer any repercussions from this choice. If employees are not free to choose whether or not to receive the vaccine without fearing adverse action, then the vaccine is not merely recommended. So, Harry, this got my attention as a labor and employment attorney, because essentially you tell your people they have to get the vaccine, they get it and have an adverse reaction, then this could be considered a workers' comp issue, and that's going to cost these employers.
No kidding. You can understand what some lawyer somewhere in the catacombs of OSHA did. He thought, well, it's required, that makes it work-related, but this is why people can be unenamored of the federal government, and I say that as a Democrat. It's just very poor coordination. It didn't go through. They're going to do a whole new comprehensive rule, and I predict this will be for the ash heap. But of course, it's likely to make employers not make it required when the federal government would like to encourage people to get vaccines. So I think it really boomerangs against them, and it's just probably a short-lived bureaucratic mishap.
Okay, so maybe it gets rolled back. To your point, though, Kevin Cannon, who's the Senior Director of Safety and Health Services at the Associated General Contractors of America, it's a mouthful, he says this: what they put forward could potentially discourage employers from supporting their workers getting the vaccine. So, David, that seems to be the frustration from folks who want to make sure everybody gets vaccinated, that if employers now worry they're going to have some liability, they won't make it a condition of returning to work.
Yeah, well, first and foremost, this is unprecedented. Why? Because we're still under the emergency use, and never in our history has an emergency use been so widespread countrywide to bring up these issues in litigation. So because of no precedent, we're really on our own here to determine what, if anything, is the law. And what they're doing is they're looking to the emergency use statute, which requires the Secretary of Health to make sure that anyone that gets the vaccine does it voluntary. And that's the basis, that it's still an emergency use, that it needs to be voluntary, and the standards are lower. But there's plenty of arguments on the other side of things, and I agree with Harry. I think that this is going to be changed quickly, because ultimately employees are at will, and the CDC even has some inconsistent language in their directive and guidelines that says that whether or not an employee can be mandated relies on state or other law. So you have CDC saying one thing, and you have OSHA saying the other thing, and nobody's getting it right, in my opinion.
Yeah, and employers are left to worry about this because they are worried about all kinds of liability. They're worried about people coming back unvaccinated, getting somebody else sick. That employee then sues over the unvaccinated person being allowed back in, or customers who come into a store or restaurant say they got COVID there. I mean, here, there's been a liability nightmare for business owners who've been trying to stay afloat during the pandemic, and now as we're hopefully transitioning out of it.
Yeah, look, I think that's right. I know that Mitch McConnell, among others, is focused on it. It's a different policy question if somebody's going to have to bear expenses of COVID-related illnesses. Should we have a sort of insurance policy that's forced through employers that employers will squawk over, but it's not unprecedented? But as David says, we have this provisional situation where we want to encourage people to do it, and somebody just blundered and interpreted the law in a way that might be good on the surface, but just not thought through. And we don't want to discourage employers who want to make it required from doing that. There's nothing wrong with that. That's not a government program. That's just a good business decision, I think.
Well, it seems both of you think this policy or recommendation from OSHA may not stick around for long. We'll see as everybody tries to figure this out and head back to their offices. Harry and David,
I'm sorry we couldn't disagree more, but I think I agree with David.
Also, Shannon, once it's out of the emergency use, there's not going to be an issue. Everyone's going to be able to mandate it.
And people have to remember that these vaccines are not traditionally FDA approved. They are emergency use technically, and it's easy to lose sight of that. All right, thank you both very much.
Thank you. Thanks.
Take care.
Always good to be here.